All right, welcome back. We'll now take on the tricky topic of managing internal investigations. And our moderator for this panel is Tom Sporkin, a partner at the Buckley LLP firm. Tom spent nearly 20 years in the SEC's Division of Enforcement in senior roles, including Chief of the Office of Market Intelligence. He also helped to launch the SEC's Whistleblower Office, helped write some of the whistleblower rules called for under Dodd-Frank. Tom, welcome back to Securities Enforcement Forum.
Thanks, Bruce. Glad to be here.
Our SEC panelist is Anita Bandy. Anita joined the SEC in 2004, and she's now an associate director in the Enforcement Division, supervising approximately 40 attorneys and other staff. Anita, it's always great to have you with us. Thank you.
Thanks for having me.
Also very pleased to be joined on this panel by Phil Khinda, partner at Steptoe & Johnson, also a veteran of the SEC's Enforcement Division. Phil is one of the top advisors to public companies and corporate boards when it comes to matters such as internal investigations. He's led huge investigations such as the CalPERS special review that dealt with pay-to-play and public corruption. And one extraordinary item from Phil's bio that I saw, no corporation or individual that he has represented from the outset of an investigation has ever been sued by the SEC or indicted. Nice, Phil. Phil, thanks for joining us today.
My pleasure.
Finally, I'm very pleased to introduce Erica Williams, who's a partner at Kirkland and Ellis. Erica joined Kirkland out of the White House, where she served as a special assistant and associate counsel to President Barack Obama. Before that, Erica spent 11 years at the SEC, where she served as deputy chief of staff for 3 chairmen and as assistant chief litigation counsel in the Enforcement Division's trial unit. Welcome, Erica.
Thanks, Bruce.
All right, let me turn it back over to Tom.
Thank you, Bruce. First of all, let me just say to the audience, if you have any questions, text them in, and if I can work them in, I promise to do so. This panel, I'm very excited to have Erica and Phil on the private practice side and Anita on the SEC side. Hopefully, we'll tease out some interesting anecdotes and takeaways from them as to the state of the art of internal investigations. Really want to learn from Phil and Erica some of the best practices and some of the ways that they've found have been effective with the staff in conducting internal investigations and the ongoing communications with the staff during that process. And hope to get from Anita some of the items that the SEC likes to see during an internal investigation, and then some anecdotes as to how some of those positive factors have played into how the SEC has resolved matters with companies that have done a really good job with their internal investigation. So let me start first by asking the private practice side, in the first 48 hours, and what are the concerns when you get a call from your client? Either they have noticed something on their own where there's a possible issue, or they've received a subpoena from the SEC. What are the things that are going through your mind, and how do you get ready to take on this challenge? And let me start with you, Phil. And if there's anything specific about the times we're in now with the pandemic and any additional twists that might cause, twists and turns, why don't you mention that as well?
So I have a lot to say on this, and I could probably take the 45 minutes, but I'm going to give you my top 3. I think more than ever now in the pandemic, there's the reveal towards, good, hard basics. In other words, the folks who really know how to do this are really in a position to help. And to my mind, in the first 48 hours, my top 3 things are these. The first thing you need is coordinated leadership, coordinated messaging. And I don't mean a PR spin. I mean thinking about the vindication of process. And so what I would say is you should never offer anything qualitative or predictive in the early going. As a securities law matter, it's because then it creates a duty to update and perhaps a duty to correct. As a practitioner, it's just, you're going to be wrong. Making some kind of proclamation on financial impact or there's fraud or no fraud is just a bad idea. So that's one. The second is think about the many constituencies. And so as I might say to Anita, look, if I look tired by the time you first meet me, It's because I've already had to deal with our board. I've had to go talk to our bankers to make sure, let's say it's an accounting case, I had to get a waiver on the line of credit or we'd be in bankruptcy. I've had to go out to our auditors, right? You always tell your auditor before they tell you. I've gone out to our employees, our business partners, and yes, of course, then to the government. And then lastly, but perhaps the most important thing, if I can leave everybody with one idea, this whole panel, it's think of the end at the beginning. What's the outcome you want? What's within the art of the possible? And so I'll say to clients, listen, or people who call, I'll tell you how to paint the Sistine Chapel, because the art lies not only in imagining it, but in executing on it. And so it's how is it that you can make this happen, and what are the realistic outcomes from where you are? And then we can get into some of the little, ins and outs of that as we go. Erica?
Sure. Before we get there, let me ask Erica to chime in here. Do you have anything to add? Are there any priorities that you have at this early stage?
Absolutely. So one of the things, I completely agree with everything that Phil said, but within the first 48 hours, and while we're getting our arms around what happened, I want to know if there are ongoing issues, something that we need to mitigate right away. I also want to know, is there a whistleblower that provided this complaint? And if that is what is generating this, I want to make sure that our client's not doing anything to retaliate against that whistleblower. I also want to just try to figure out, is this something that might get outside of the organization? And to Phil's first point on coordinated leadership and messaging, the press can really exacerbate things. And I found in recent years that sometimes the staff is always reading the press. And depending on what the press reports, true or false, that can really alter your investigation from the government. And so you really want to get a press strategy together and make sure that you're prepared in case there are any press stories.
Great. So let me now turn it over to Anita. Anita, sometimes, when the defense counsel makes its first call to the SEC and it has that first conversation, sometimes I get the feeling that, the SEC thinks that they're the primary, the primary concern for the entity should be the SEC. And you've just heard from Erica and Phil about all these other constituents and all these other, concerns that they have running through their mind. What do you want to hear in that first call today from outside counsel to give you some comfort that that things are being handled well enough, at least at the early stage, that hopefully they'll be able to conduct a good investigation and have an outcome that you'll be able to work with?
Sure. Thanks for the question, and thanks for moderating this panel. Before I address your question, I just want to get our standard disclaimer out that the views that I'm going to express today are really my own and don't necessarily reflect the views of the commission or the commissioners or its staff. But getting to your question, Tom, I think, the key here really is to build credibility with the staff and inspire confidence that the company has this under control. The earlier the company reaches out and does so, the better. And it's important to maintain that level of confidence throughout the course of the entire investigation. And that means having a plan that isn't designed to be a whitewash, remaining objective and staying true to the fact-finding mission. The actual steps that a company takes can take different forms, and we really try not to be too prescriptive about it. But it really comes down to forthrightness in our investigations, being upfront and prompt about issues that arise and not waiting until the end or waiting for us to discover issues. So, just to put a finer point on that, it could mean a lot of different things. It could be simple things like reformulating search terms and custodians in light of evidence or hearing the staff out. It could be providing an understanding of the work plan in terms of the scope, providing regular updates, which gives us a chance to reformulate our investigative priorities and streamline, and it helps with our, narrowing of the issues. It could be things like helping to identify witnesses in a timely manner, or even stronger, identifying witnesses that we may not have discovered without the company's help, or coming in early and explaining what key roles certain witnesses had. What are their roles and responsibilities? Where do they fit into the reporting structure? And providing summaries of information on policies, procedures, controls. These things are really critical because they they allow us to narrow down the scope of future document requests or prevent boiling of the ocean in terms of how many witnesses we need to talk to. So I think, and if there's a timing issue, I think a company's willingness to give us a tolling agreement, which then gives us the luxury and the option to be flexible is a key issue. But I think the point I'm trying to make is that companies have a fair amount of flexibility in the approach that it wants to take, and that this is really an opportunity for the company to be proactive and look for ways to advance the SEC's investigation rather than hanging back and being reactive to staff requests. And then finally, the one thing I'll add is that, I'm sure this is true of the defense bar, but it's equally true on our side, who the company is choosing to represent them, certainly goes into our decision making. We know the reputations of the members of the defense bar. We know who we can count on in terms of really giving us an internal investigation or internal reporting that has integrity. We know the people that don't have that reputation. So certainly that goes into the mix, but really it boils down to credibility, building credibility through these actions early and often.
So Phil, before I go back to that, Phil's probably on the edge of his seat, wanted to react to that. But before we get to Phil, let me ask you just two questions on that, Anita. First is, you mentioned reputation of the attorney that you get the call from. Does that, first question to you is, do you want to see, will you judge independence at an early stage? Does that play into how much forbearance you will give to a company, to try and, conduct their internal investigation without forcing deadlines for completing certain of the staff's requests?
It's a really good question. I think we leave it up to the companies and their audit committees and their boards to really decide in terms of whether it wants to bring in independent counsel. But we'll be looking closely at whether the company was transparent, forthcoming, and objective, and not clouded by their prior potential history with a company. Again, it's all about establishing that credibility, and we're going to be looking at it through all different lenses. But I think, we don't interfere in that decision. It's completely up to a company and its board to make those kinds of decisions. Drilling down a little further in terms of issues of conflicts, I know you did ask, but it's sort of an issue that goes hand in hand with these kinds of issues. Oftentimes you see counsel that are representing multiple witnesses. Again, we trust counsel to comply with their state ethical obligations on those types of issues. We wouldn't try to interfere in that decision making. But companies cooperate through their employees, and it's fair for us to assess under CBORD, whether the company's decision to represent multiple witnesses despite an appearance of a potential conflict prevented that witness from being candid in testimony, or deprived a witness of the chance to cooperate and put themselves in a better position because the conflict was not properly considered. So again, we defer to these judgment calls, but those judgment calls have ramifications in an investigation, and that's fair game for us to take into consideration alongside other CBORD factors.
All right, Phil, Erica, any reaction to what Anita just said?
A couple, if I may. It seems to me, first of all, you and I came into this game, as it were, at just the end of the era when the old guard would say, not to worry, I am counsel to the situation. And they would work out the whole thing. But for the practitioners out there, especially those newer to the field, I think you'll see there's a perfect connection and merger between a great point Erica made and what Anita just said, which is, in the end, you talk about independence. Independence is a proxy for something more important, and that's integrity. And so whether I'm here on behalf of management or a board or board committee, it's watch how we do this. And so to Erica's point, if we find the problem, it stops the day we find it, and we build a wall around it. And that was then, and this is now. And this is why we don't say anything qualitative and predictive to Anita and her team, because once my credibility is gone, all the king's horses and all the king's men can't put it back together again. Right? That's it. That's the stock and trade. Watch how we do this. And here we are, predictable milestones, and onward and upward we go. And then it's building an outcome. As I said, think of the end at the beginning It's building an outcome that you'll not just be happy with, but that will stand the test of time, because you have to believe that there are going to be private litigants, unhappy other people, and it's following the facts where they go, and it's reasonableness and line drawing.
Great. So Erica, let me ask you, first of all, feel free to follow up and give any last thoughts on that. But I also wanted to broach a new topic with you and kind of get your thoughts on how often do you want to be in communication with the staff after you make that first call and you get some comfort that they will likely give you forbearance to go forward and conduct the investigation? What is your practice with regard to regular communications with the staff? And what are some of your thoughts about that?
It's a great question, and it really depends on the matter. And so I have some matters where I'm in contact with the staff every week. We have a standing call. And in those matters I know that every week there's going to be an update because things are fast moving. We're producing documents, there are outstanding questions. And part of what I always want to do in order to maintain credibility and reputation is also to be transparent and open with the staff. My client depends on me to do that because cooperation credit is so important, and part of that cooperation flows through me. So there's some matters where it's just fast moving every week. I have other matters where I reach out maybe twice a week. And then there's some where we reach out initially, we tell the staff what we're going to do, and then we don't have to talk again for maybe a month while we're producing documents or getting questions together. But it's not that the staff doesn't know what's going on. I kind of treat this like I did calling my parents when I was in college. I call them so they didn't have to call me and didn't have to worry about me. And it takes some judgment and it depends on the circumstances, but that's how I approach this as well.
So Phil, let me ask you, what is your practice with regard to, keeping a tight leash on the staff so that, you kind of can feel them out on a regular basis and give them updates, but also get comfort that they're not going to, do anything, as we would say, maybe irrational. What do you like to do?
Well, I don't think you need to keep them on a leash, and I don't think they act irrationally. I think they're hardworking, right-thinking people, but they're at a disadvantage sometimes in terms of information. And so part of my job is I can't always control the facts, and this is maybe the difference between defense and internal investigation, right? In a defense scenario, often you're just managing their disappointment, and you don't control the facts. You might control the prism through which the facts are perceived, which is look how hard we're trying now. In an internal investigation, though, I think we all want the same thing, right? The corporation, even if the government were to go away, here's the ultimate test. Even if the government were to go away, the company is still going to resolve this. And so to Erica's great point, often surprise masquerades as crisis. And so when people are hearing things unexpectedly, it seems much worse than it is. So often I believe the government and others, whether it's the board, the auditors, they should hear it from me first. They shouldn't hear it around the way, right? Mom and dad shouldn't call me and say the neighbor said. No, they should hear it from us and say, here's what it is, but here's what it isn't. And here's what we're doing about it. And here's when we'll be back to you. And so it's managing those expectations. And it's, again, no different than I would tell the bankers, the board, the auditors, all of them. And the magic is making all of them feel that they're first on your list. And so I can tell you, Bruce mentioned the CalPERS thing when he introduced me. One of the oddities in that matter was the U.S. Attorney's Office, for those of you who know San Francisco well, is literally across the street from the AG's office on Golden Gate Avenue in the Tenderloin. God forbid one of them cross the street and talk to each other. And so I would end up having to cross the country, go into one building, cross the street, go to the other to make sure everybody knew what was going on. And then, of course, visit with the SEC and the IRS and the others. And in that regard, it's not a leash, but knowledge is power. And so since they wouldn't talk to each other and they all talked to me, there was a certain advantage there.
Well, let me ask Anita. You've heard from Erica and Phil on how they like to, kind of keep in the loop, keep the staff in the loop. What do you want to hear from the staff when they call you for a status check-in? What do you want to hear that gives you comfort that the internal investigation is moving along in a manner that inspires confidence that they're doing it the right way and that you can continue to forbear?
Yeah, I mean, I think that calls are important to make sure that things are moving. It gives the parties a chance to constantly reassess priorities and make amendments to pre-discussed plans for production and timing issues. But they should only happen at the frequency that offers utility behind the calls. And so, what do I mean by that? It's important to understand from the get-go the scope. Does the company actually have a realistic appreciation that's aligned with the staff's concerns? Are they moving in directions that are just inconsistent with what we already know from maybe a whistleblower or another source of information that we're hearing from? So understanding scope, concrete next steps, and getting real-time reports is really critical because the real-time reports give us a chance, again, to narrow down the issues, to really zero in on documents that matter most, witnesses that matter most, on the issues that matter most. But, in terms of the question of forbear, I mean, I'm not sure that there are many cases, even under the best case scenario, where the company is doing actually an exceptional job that we would forbear. I think really what we're looking for is, if the company can establish that credibility up front and it creates an environment immediately where the staff may be receptive to restructuring its investigation in a way that doesn't interfere with an internal investigation or cause duplication of work. But it's really rare that we would just hold our investigations in abeyance, waiting for the company to come back to us, because there are other things we can do. Oftentimes we're on parallel tracks developing the record through a whistleblower. Maybe we're coordinating with criminal authorities. Maybe we're going to outside third parties, like the auditor or the counterparty to a deal or a consulting firm, an appraisal firm, whatever the case is. There are ways that we're also developing the record that might go beyond the jurisdiction or the authority of a company's internal investigation. The other thing I'll say is, look, even under the best case scenario, again, there could be statute of limitations issues, right, with a former or present employee that prevents us from, to use your word, forbearing as much as maybe circumstances would otherwise warrant. Another thing is it might be in our interest to reach out to the outside auditor before a 10K is filed, before they're sort of bound by the 10K process to understand early on and lock in the auditor's perspective. There could be witnesses that are beyond the jurisdiction of what the company can do, but we can work with foreign regulators or use our subpoena authority. And so where we have those issues, we try to be transparent with the company so they understand that we're not holding our process in abeyance, for good reason. Where we can, we try to be transparent about that. And in the meantime, I think there's a lot of things we try to do that doesn't duplicate the company's efforts, but still allows us to make progress. And some recent examples of that could be that we could ask, even while the company is doing an internal investigation, we could ask the company to give us a proffer on controls or policies or procedure that don't interfere, but still allow us to, in real time, develop our own record. We could be providing ROG-style questions for the company to answer early on. So I think that there is a way to do it where we're not forbearing, but we're not also interfering where that credibility has been established.
Great. Let me ask Erica. You've just heard Anita very eloquently, make that statement. Are you doing anything, different to keep on the good side of the staff now that we're in this pandemic? Have you faced any challenges that make it hard to meet some of these, some of the expectations that the staff might have in gathering information? Is it harder to get, witnesses to show up? And to provide information. Any unique challenges with the pandemic?
Absolutely. And primarily the challenges that we've had have been collecting documents and also preparing witnesses. It just takes more time. It's a challenge to get your arms and for your clients to get their arms around certain documents. And because of that, I think what we have tried to do is, or I personally have tried to just have more frequent discussions with more detail to the staff about what the challenges are with respect to document collection and production. And I have found that transparency, where I might not in the past have gotten into the nitty gritty of it, primarily because we didn't have to. I don't think that just saying, oh, the pandemic is causing us challenges is enough. Right now, I think that being very candid about how we have put in document preservation orders, but let me tell you the challenges that we're having in producing the documents in a timely fashion has been very much appreciated by the staff, because I want to produce the documents as soon as possible. And so does my client. It's just as a practical matter with people being off site, that's been a challenge, as has been occasionally scheduling witness interviews and preparing witnesses. And, I know that I've been doing interview prep super late at night, really early in the morning, whenever my witness is available, because just like all of us, they have challenges of life. They have children at home who are trying to, do schooling online. They have a lot of things going on. And I feel that the staff has been extremely cooperative and understanding about that. But for my purposes, to get them to be understanding, I need to be really transparent and open. So that's what I've been doing.
So Phil, you just heard Erica say that the staff in her instances, for the most part, have been cooperative, with the challenges of the pandemic. Do you agree with? Do you have the same experiences?
I think it's, it depends. It depends. Each office has its own personality. Each staff attorney kind of conducts themselves differently. But I think that, to my mind, the 2 points I want to underscore from both what Erica and Anita said are these, because I think they go beautifully together, which is, are things different in the pandemic? Sure, but every one of these matters is a bespoke matter. There's no playbook, and anyone who tells you there are disciplines, there are skills, but each one of these has to be tailored. Likewise, forbearance, I think, is a mistake. And I think there are a lot of folks who come into this space who play defense, who want to stiff arm the government. And I think it's a terrible mistake. One, because it puts them off. But two, remember, if I'm doing an internal investigation, I got to rely on the kindness of strangers, right? I mean, I can be charming, but there's only so many people are going to talk to us if they don't have to. Whereas if I go to the government and I say, listen, I've come to the river's edge, but I'm telling you right over there's a whole lot of good information. And if we have been forthcoming enough, I've had plenty of good experiences with both state and federal officials, including the SEC, where they've come back and they said, hey, what do you make of this? What do you make of that? We were able to learn this. We were able to learn that. Because in the end, it's the same idea of a common interest agreement. We all want the same thing, right? And so in the same way, I don't self-report till the story has a happy ending. But if we're in this together, we're working towards the same objective. That's it. Now, they might be focused more on remediation, penalty. I've got to make sure the company also knows how to work. And if they go away, that, we keep going along. And I have to deal with the realities that Erica mentions, which is, time differences, schedules. You just have to be accommodating all around. And the good and the bad of working from home is I live at work. And so you're basically available 24/7 and you make it work for everyone. So that's where that is.
Okay. Let me ask Anita, when do you want to hear the first substantive, kind of deep dive download from the outside counsel? Do you, and what form, like, do you want to hear a proffer like 30 days in? Do you want to hear some type of proffer? I heard Phil say, it'd be great if, I think I heard Phil say this, and Phil, I'll turn it to you after Anita goes, but, there might be some benefit of, getting only putting one report in at the end when you're absolutely confident that the facts. Facts change, and as you talk to more people, you learn more. So first 30 days can often, the conclusions an outside counsel makes the first 30 days always subject to change and often do. So when do you want to hear, kind of a deep dive into the, in a status update as to what outside counsel is finding?
Sure. I mean, I think there really isn't a one-size-fits-all approach. It's really facts and circumstances. But just speaking generally, look, we leave it up to the company in determining the manner and the timing of when it wants to present information. It doesn't have to do anything, right? It's a choice that the company is making. But if the company wants to be effective in terms of getting us salient facts in a way that accelerates our investigation or saves the parties the trouble of making overbroad requests, then the earlier the better. regardless of when you want to do it, how you want to do it, whether you want to do slides, a PowerPoint, do it on the phone, come in for a meeting, what we're asking ourselves is, is the company giving us salient facts? It's giving a head start on our investigation that's causing us to enhance the quality and the efficiency of our investigation. Are they reporting, what actually took place? Are they taking accountability for where breakdowns occurred on a real-time basis, which goes to things like self-policing and remediation? Typically, if the company wants to do something earlier, it's always better to get the documents. It's always better to get the key documents or their assessments on credibility on witnesses or who the people are that would be most relevant in our investigation. And look, I think, we can't always take counsel's word for what's happening. So documents always help. We're going to ask for it eventually. So the sooner they can give it to us and let us get a head start, the better in terms of resource conservation on both sides. And that meaningfully, I think, goes to how we're going to be looking at cooperation. But I think that, the other thing, this goes to Phil's issue in terms of, sort of the gamble in terms of when and how much. I think it is important for companies that when they are coming forward, that they are, again, being forthcoming and they're presenting the issues in a fact-driven, objective manner. Because remember, by this time, we're also developing the record to some degree, either through a whistleblower, a third-party witness, documents that we may have collected from third-party sources. And so credibility is on the line, both for defense counsel and the company. And we're assessing what's being presented up against the record that we already know. And so, again, it's sort of like this balancing act. The more candid the company is, the more wider of a runway and flexibility we might show in terms of our next steps. So I think those are important things. Just because the company doesn't have perfect information or full information isn't a reason not to come forward, because I think there's too much to lose in terms of how we're assessing cooperation.
Great. And Erica, let me ask you, when do you think there's any utility in trying to get in early, say within the first 30 days, to present information, maybe to try and help inform on how the SEC might alter an investigation plan? If you can show them, hey, we found that's there's no big issue there here, but there is an issue over here. And when do you, and just when do you in general like to make your first, more detailed presentation? What have you found as effective?
It really depends on the matter. I've absolutely tried to go in the first 30 days in certain instances, especially I had one matter where there was a lot of press attention and there were stories that were false, but also and very damaging, ongoing damage to our client because of the falsity of them. And we understood that some of the leaks to the press may have been coming from third parties who'd received subpoenas. And so for us, it was very important to try to go in early, not with a presentation on the entire investigation, but on this very small bite-sized piece that was harmful to our client in the press, to try to just resolve that issue as soon as possible. And there are times when bite-sized presentations are helpful. Maybe I don't have my arms around everything that's gone on, but I can break it up. I always want to go in, though, when I have an understanding of what happened. I never want to go in when I'm still trying to figure it out, because I don't want to present any information that's not accurate. So if I'm going to go in with a bite-sized piece, I need to know everything that I can about that. And sometimes that requires, lack of sleep and working all night to figure out what I need to put in this presentation. But it is a facts and circumstances calculation. And in general, you just want to know that when you're going in for a presentation, what you're saying is accurate.
Phil, let's jump to the end when you make your final presentation or your formal presentation of the staff. What have you found? What do you like to do? What are some good practice points? What do you find is effective?
Well, so I'm going to speak to two things. The point there, the early going and at the end, I'm happy to do that. I don't have a fixed rule like Eric on this, but as I think back on it, as they were talking, probably in every single matter I've handled, every internal investigation, if I wasn't in touch with the government in the first 48 hours, I was probably in their offices in the first week. And in part, it was to say, here's who we are, here's what we're doing, here's how we're going to do it. We're going to be looking anyway, by the way. If there's anything you want us to hunt for, right? We're going to the store. If there's anything you want us to pick up, tell us. You good folks of the United States government, you're going to be, storming the beaches of Normandy. If we can play Churchill, we're happy to play it too. We're happy to play whatever role is helpful. And frankly, again, if you go away, we're doing it anyway. Now, at the end, again, it depends, right? Sometimes you got to think of it from a governance perspective too. Not every matter requires the Enron 4-volume set, right? Not every matter, like the CalPERS matter, requires a public report or that ends up in a business school case study. Same thing with our, our market timing. Sometimes at the other extreme, it's enough to have a presentation of the board. Mr. Khinda addressed the board, questions were asked and discussion ensued, right? And so I will just come to the SEC and say, listen, given all the collateral litigation, it's not that I don't trust you good folks, right? But Mel Weiss, before he was busy getting indicted, I don't know what he's going to do. And so let me just tell you what's happening. Other times, you want to have a slide deck because what you're trying to create is a deliverable, not so much for the SEC, though they appreciate it. But should it get out, you want to document that should the plaintiff's bar get a hold of it, again, another not shy group, that whatever the hell they think of it, the diligence of the company and the board are not in question. So that's the spectrum. Every matter demands its own result. And anybody who thinks, oh, this is like that, is just selling you something off the shelf. And I would suggest to you it's a mistake. Okay.
Anita, we mentioned cooperation a good deal already, but is there what's the state of the art? Are you expecting, as you said, tolling agreements? I heard you say that if you do execute a tolling agreement, that often will give you some comfort. But are you expecting entities to, provide information on executives that, may have caused the conduct under investigation? I think I heard you mention the Seaboard factors and say that that's still the state of the art. But is there any additional and anything else that we can take away in 2020 when we're considering how best to cooperate?
Sure. It's a great question and one that's always relevant to these kinds of panels. Look, I think broadly speaking, we still evaluate cooperation in terms of the Seaboard factors. It's just as relevant today in the present COVID era as it was in the initial 21A report that was issued in 2001. So we largely do look at cooperation on, the factors that we've always looked at, and I've said it before in today's discussion, what we're looking for is, did the company provide information to us, material information that ultimately enhanced the quality and the efficiency of our investigation? Did it give us a lead? Did it give us access to a witness or documents that would otherwise be difficult for us to access because of the COVID pandemic, because of jurisdictional issues? Did the company translate documents to us so that we were able to comprehend and build our record in a more efficient manner? Ultimately, did it cut down the time it took for us to pursue this matter? And did it give us leads that we otherwise wouldn't have had without that level of cooperation? And so, what it doesn't mean, it doesn't mean, that, producing documents or witnesses that were otherwise legally compelled by subpoena or telling us how much the company spent, as part of its internal investigation or part of the SEC's inquiry isn't gonna cut it in terms of cooperation. We're really looking for, did the company's cooperation substantially enhance, again, the quality and the efficiency? And I think a really great illustration of COVID era cooperation is reflected in the recent case that we brought against BMW. This was a 17A fraud action that we brought against the company for false and misleading disclosures regarding its U.S. sales volumes in connection with several 144A bond offerings. It was a very, very complex matter that spanned several years, involved several improper sales practices, and there were evidence gathering challenges from jurisdictional issues, and more importantly, the global pandemic, which really impacted the company's operations both in Germany and the United States. But despite these challenges, as the order lays out in a lot of detail, and I encourage everybody to read the orders because we try to be very transparent in the types of actions that we are crediting. The company took a lot of steps to be proactive and forthcoming, and really the actions resulted in our ability to, despite a global pandemic, bring a complex fraud action within 10 months of starting the investigation. And it included things like producing documents from Germany within a matter of weeks of getting the request, which otherwise would have been difficult. Quickly producing witnesses on our timeline. And once being contacted by the staff, BMW voluntarily reported certain sales practices and remediated, which is a great takeaway that, just because you don't have perfect information or you have information even after the staff contacts you, it's still not a reason not to self-report, because there is still substantial, exercises of discretion that we can wield. And so I think this is a really good example. A couple other notable examples would be PPG Industries, which we brought in 2019, and Transamerica Asset Management, which we brought this fiscal year. In both matters, as the order lays out, in BMW, we imposed a reduced penalty. In these matters, because they were genuine self-reports from the get-go and other seaboard factors were met, the commission imposed no penalty, and the order does a really nice job of laying that out. The one other, you had mentioned tolling. Look, in terms of the issue of tolling, we don't take away cooperation points if a company doesn't want to give up a legal right, like giving us a tolling agreement, or giving us a waiver of privilege or work product. But certainly if a company voluntarily provides those things, and those are salient, and that allows us to get to the finish line in a substantive, and efficient manner, those are going to be positively weighed. But we don't take cooperation points away, when a company chooses not to give us a tolling. But on the other side of that coin, if we don't have a tolling, then we might not be as flexible in terms of turnarounds for document productions, the Wells process. We may not be as amenable to those kinds of considerations, when that doesn't happen. The final point that I wanted to relay is that if a company is inclined to self-report, no matter at what stage, whether it's before we start an investigation or in the midst of it, or even towards the tail end of it, it's important to do it as quickly as possible, because, if we discover the conduct through other means, including, our whistleblower program, which had an incredibly impressive year, record-winning awards, and just an outstanding program, or, through other means like, working with criminal authorities, there's a lot of ways that we can discover conduct. And if that happens, then certainly the ability to earn the full spectrum of cooperation credit is certainly impacted. It could be diminished. And so companies are really taking a gamble, in sitting on information that could inure to its benefit. And, as I always like to mention, conduct has already happened, right? The company isn't in a position to change that. What remains in its control is how it chooses to respond in terms of remediation, in terms of being proactive and forthcoming with the staff. That's really the only thing that remains in the company's control. I think we encourage companies to take advantage of what does remain still in its lane.
Great. Well, that's very I'm going to throw the jump ball over to Erica and Phil in the last minute and a half, and see if any of you want to react to that, or if you have any anecdotes of your own where something you've done that has been creative, you think has resulted in one of your clients getting a nice downward departure from what they might otherwise have had in their resolution with the SEC.
Erica, please. I'll go right behind you.
Look, I just think that, to Anita's point, having just a sort of a culture and a spirit of cooperation, I always tell my clients, we don't know now how this is going to inure to your benefit, but If there is any wrongdoing that the SEC finds, you want to make sure that you have cooperation credit. And if you didn't do anything wrong, then you need to also be as cooperative as possible. It only benefits every situation. So that's my overall view of it. Phil?
I would simply add, woe to the person who brags about how much the investigation cost. There's a great forensic person out there who I won't name now. The portfolio company we were thinking of investing in said they did a $40 million investigation. And I'm not kidding. In 15 minutes and 3 questions, we had brought them to their knees. And so, silly. Look, this is a remarkably complicated area. It's one where I tell folks, again, as Erica pointed out, you got to have the right advice. I'm always happy to kick these ideas around. And so as I learned from Harvey Pitt, any question, any call I don't have to prep for or schedule, it's on me. But Tom, I want to thank you, and Anita, Erica, wonderful. Thank you so much.
Thank you, Phil. Thanks, Erica. Thanks, Anita. Bruce, I think I got you right on the timeline.
Perfect timing. And thank you, Tom, and to the whole panel. Great job. Really appreciate everybody's insights. And that's a great topic and really good to take a deep dive on that. We'll be back to take a look at the particular enforcement and regulatory developments concerning financial firms in 5 minutes at 3:50 p.m. See you in a few minutes.